Hey there, have you ever felt completely powerless when a public body makes a decision? You know, that feeling that something's just not right? Well, today, we're diving into the legal toolkit that actually puts some of that power back in your hands. It's called Judicial Review, and it's how regular people can stand up and challenge the decisions of some of the most powerful organizations out there.
Okay, let's make this real. Picture this. Your local council just announces they're shutting down the only library in your town. And get this, they didn't talk to anyone, no consultation, nothing. It just feels wrong, right? Maybe even illegal. So what do? What can you do? The answer, it turns out, is a legal process that's pretty powerful, and we're about to unpack it.
Right, so holding power to account, that formal process we just hinted at, that's judicial review. The best way to think about it is like a referee in a game. Its whole job is to make sure the players, in this case public bodies, are actually playing by the rules and using their power the way they're supposed to, lawfully.
So what exactly is it? Well, here's the definition, but I want you to focus on one key word: legality. You see, judicial review isn't about whether a decision was popular or even if it was a good idea. It's a super precise legal check. The court is asking one thing: did the public body follow the law? Did they follow the right steps, the correct procedures when they made that decision? That's the game.
And this is a really big deal because it means everyone is equal before the law. A landmark case, M.V. Home Office, basically hammered this point home. It confirmed that no one, not even a high-ranking government minister, is above the law. So when a court issues an order, you have to obey it, period. That right there is the rule of law in action.
All right, so who can sue whom? Let's get into the nitty-gritty. How does this whole thing actually work? Well, before a court will even look at your case, you've got to get through two crucial gates. The first two questions are, who exactly are you suing, and do you even have the right to sue them in the first place?
So, who can you actually challenge? Well, the list is pretty long. We're talking about ministers of the Crown, your local authorities, NHS trusts, even universities and the police. Basically, if a body is carrying out a public function, it's probably on the list. The famous GCHQ case was a huge deal because it even brought some of the Crown's old, historic powers under the court's microscope.
Okay, so that's who can be sued. But now, who can do the suing? This is that first gate I mentioned. It's called the sufficient interest test, or locus standi if you want the Latin term. It basically means you can't just challenge a decision because you disagree with it on principle. No, you have to show the court you have a real direct stake in the outcome. So let's go back to our library example. If you're a local resident who actually uses that library, yeah, you'd almost certainly pass this test.
Okay, let's say you're through that first gate. You've got sufficient interest. Now, you've got to worry about beating the clock, because as soon as you're in, a timer starts. And believe me, it's a strict one. You have to act, and you have to act fast.
How fast? 3 months. That's it, 3 months. You have to file your application for judicial review promptly, and always within 3 months of the decision you're challenging. And there's a really good reason for this strict deadline. It's all about good administration. You can't have public bodies constantly looking over their shoulder, worried about a legal challenge from years ago. It would paralyze everything.
Now, is that 3-month rule completely set in stone? Well, not entirely. The court can grant an extension, and this is a big but, only in really, really exceptional circumstances. So the takeaway here is super simple. If you think you have a case, don't wait. Don't delay. That clock starts ticking the second that decision is made.
Okay, we've talked about who and we've talked about when. Now we're getting to the absolute heart of the matter. This next part is probably the single most important thing to understand about judicial review. It's about the process, not the merits of the decision itself. And this is what makes it so different from almost any other kind of legal case. And this quote on the screen, I think it explains it perfectly. Think about it. A teacher checking exam instructions, not remarking the paper. That's brilliant. The court's job is not to decide if closing the library was a good or bad idea. They aren't going to step in and say, well, we would have kept it open. Nope, they're just the referee for the process. They're asking, did the council follow the rules? Did they consult everyone they were supposed to? Did they have the legal power to do this in the first place?
So this really brings us to the key difference between a judicial review and an appeal. Look at the screen. An appeal is all about the merits. A judge looks at a decision and asks, was that the right call? And if they think it wasn't, they can just swap in their own decision. But judicial review, totally different. It's all about legality. Was the process lawful? And if it wasn't, the court doesn't make a new decision. They just cancel the old one, quash it, and send it back to the public body to be made again, but this time correctly. So, let's say you've navigated all these steps. You've passed the tests, you've beaten the clock, you're at the end of the road. What happens now? Well, there are still a few potential roadblocks to be aware of, but also some pretty significant rewards if you win.
One of the biggest roadblocks you might hit is something called an ouster clause. This is basically a bit of text that Parliament writes into an act that tries to, well, oust the courts. It's them saying, hey judges, this decision is none of your business, stay out. And this creates this incredible constitutional tension. On one hand, courts have to respect that Parliament is sovereign, but on the other hand, their entire job is to uphold the rule of law. It's a real clash of titans.
Another important rule to know is the exclusivity principle. You can think of it like this. You have to use the right tool for the right job. If you're challenging a public law decision, like our library closure, you have to use the judicial review process. You can't try to sneak it in through some other door, like a normal private lawsuit. And this makes sense, right? It protects public bodies from being hit with all sorts of random or delayed challenges and makes sure these specific cases are handled by the process that was built for them.
Okay, so let's talk about the rewards. If your claim is successful, what can the court actually do? Well, they've got three main tools in their belt. First, a quashing order. This basically undoes the original, unlawful decision. It's wiped from the record. Second, a prohibiting order. This tells the public body to stop what they're doing if it's unlawful. And third, a mandatory order. This forces a public body to act, to actually perform a duty that they were legally supposed to do, but haven't.
And all of this really brings us to the big central question, doesn't it? Is judicial review a vital check on power that keeps our government fair and accountable to everyone? Or is it a massive hurdle for an efficient government, letting unelected judges get in the way of what elected officials are trying to do? The answer, of course, isn't simple. It's a constant balancing act. And that tension, well, that's really at the heart of what it means to live in a modern democracy.